It's initializing. Here we go. We are live.
Oh, yay.
Hello, everyone. We are here for, I think, episode 11. I do not know why I find it so difficult to keep up with how many weeks we have done now. We've got a couple of people joining us, so that's good. We are here with Lana today to talk about estate planning. Estate planning being what exactly, Lana?
Everything that is you, everything that makes up you. But in terms of what I do and how I help my clients through that process is the starting point is typically knowing what you own and knowing how you own it, and then knowing that where it flows when you die. Like, it sounds really blunt, but it's really an empowering process because a lot of people don't really realize, oh, if I've got, my name on the house with somebody else, technically you're owning it as joint tenant. So it gets really technical, but I help you through that process. It's knowing what you own and how you own it.
Yeah. And you're in the car today. And where are you going? Because I think that this is something that maybe not a lot of people realize that an estate planning lawyer would do.
Yes, so I'm tuning in from my car. I've parked up close to where my next appointment is. So I've had quite an urgent set of instructions come through to me. It's a client so I physically have to go and see them, their instructions about their last will, which is, look, it's never the best of circumstances, but it's like, I feel like it's a privilege that I get to do that and honor somebody's last wishes. And that is kind of my point of difference with the way I run my business is I'm mobile. So even though we had booked this session, I had to move things around in the background to make sure that things just worked out.
Clients come first. Yeah.
Clients come first, always.
So based in Brisbane, but also offer virtual services Australia-wide?
Well, I like preferably Queensland-wide. Like, I can do Australia-wide, but I like to keep quality work. I like to make sure that I know exactly what the laws are, and you would know each state and territory has different pieces of legislation. So yeah, Queensland is a preference for sure.
And so part of today's session is around getting a will done, a really manageable step. So probably unsurprisingly, the easiest thing to do to get that ball rolling is to actually just make an appointment with someone. So if you are someone in Queensland and you want to get this thing off your life admin to-do list, you can of course book in with Lana in Queensland, or Lana, you, I'm assuming, are able to refer on to other lawyers that you know and you trust in other states and territories then.
Yeah, absolutely. I'm part of a group of estate planning lawyers from all across Australia. We meet every week. We discuss live files that we have going on, and we kind of workshop through that. I think there's like 120 of us. That it keeps growing. And yeah, so there are amazing estate planning lawyers all across Australia. So I'm happy to refer on to some of the people that I personally know.
Yeah. So what happens if you don't have a will and you pass? Right. What happens in that scenario? What's that called?
That is called, so if somebody passes away, they pass away intestate. So the intestacy laws under the Succession Act of Queensland, they kick in. They're like the default plan. That's the government saying, if you die without a will, here is the plan. Like, here are the priority people who get your assets, and here is the division of those assets to those people. And typically it's not what people want.
What does that look like in Queensland? What's the order?
Oh, it really depends on who the person is. So, single, no dependents, typically defaults to parents if they're alive, and then it goes through like a priority list from there. Couples, it'll default to the surviving spouse and then the children in the same space. So typically couples want everything to each other in the first instance, and then when they both die, all to the kids from there. But the intestacy laws don't do that. Like, that might not happen. So it's just, every time I'm doing somebody's estate planning, we talk about intestacy laws and align them with what their actual wishes are. It's never 100% on point. And there are things, there's another, superannuation is always this big topic. People don't realize that that does not by default fall into your will or fall into your estate. You have to tell the super fund by way of a binding death benefit nomination where to pay that. But then that gets really technical because, I've seen people nominate beneficiaries who don't fall within the definition of a dependent for superannuation purposes. And then
Yeah.
there's like another definition for tax dependent. So it gets really messy
See it all the time.
all the time, right? And I've got a file on the go at the moment. It's literally been a year and a half since the father died, and the family cannot access the money because he had an invalid nomination at the date of his death. So the family know, like, well, I knew him personally, so I knew he would have probably wanted to spread it amongst his children evenly, but he's got adult children and minor children, and it's just really complicated. So the reason why it's tied up is because the super fund has to do their due diligence to make sure whoever they release that money to is the right person. So these are things we cover in an estate planning strategy session, as well as, you know, so many other things. But superannuation is typically the aha moment for people, because they'll say, oh, I don't have enough money in the bank to justify getting a will done. I will say, that's great. Go and check your super balance and go and check the life insurance that's attached to that. And we're typically talking hundreds of thousands of dollars that you're leaving it to somebody to put their hand up and say, pay it to me if you haven't got that strategy right. So yeah, I could go on and on, but
So let's say
superannuation is
someone passes away without a will and the intestacy rules actually do match what they would like to happen. What are some instances whereby it's still worth seeing an estate planning lawyer? So I'm thinking in that regard in relation to someone who maybe has young children and a lot of life insurance. What path may they go on that is different to just the normal intestacy rules?
so I would say for couples with young children, the intestacy laws they hardly ever align with what the person wishes, because what it does is it gives, say the spouse who died, owned the family home in their name only, and then they had a whole lot of life insurance and all of that, and hopefully they've taken care of the binding nomination to bring it either into the estate or to their spouse and children. But the intestacy laws for couples will give the first 150,000 of the estate to the spouse and then divide the rest amongst the spouse and the children. So the parent then has to put a different hat on and put the children's money away in separate bank accounts, and they are then the trustee of those funds. Where it would have been just probably so much easier to give it to wife or give it to husband who survived, all, and then hopefully they've got their estate planning done and then they're leaving it to the children on trust or however. You know, it can create situations that people don't realize. It's just unnecessary bumps for the surviving family members.
Yeah, and that's probably a very hard time for everyone involved. And if there's more stuff to deal with, it just makes it so much harder. So by sorting it out now, you're basically doing everyone a favor that they can get through that period and not have to deal with all of the extra burden of going through that.
Absolutely. Grief is a curveball, you know, so navigating through all of the legal loopholes, or just even knowing, like, how can I access my spouse's super, you know, like, how does that even happen? People really don't realize the rigmarole it can be. You don't, just by virtue of being married to somebody or being in a long-term de facto with somebody, if you don't have the right documents in place, you can't just access their bank accounts or the superannuation. You know, that's when confidentiality and privacy laws kick in. You need to prove you are the person with the legal authority to deal with these assets. So yeah, it really is just clearing up that mess, really, like leaving your plan that everyone has a plan. Like, everyone knows how important these documents are, how important it is to put a will in place, but just taking that step it's like, I feel like, and I've said this before, it's a responsibility of especially parents, but even spouses, to do that, to clear that mess up for your loved ones.
And I find with super as well, because for a lot of the people that I'm talking to, it's not necessarily front of mind because they can't access their super. But then when we dive in and just have a look at what they've got, because a big part of financial coaching is really understanding your current financial position, we work out that the beneficiary is maybe an ex-girlfriend, ex-boyfriend, or we've got ex-spouses, we've got parents who are not eligible beneficiaries. So who are the people that can be eligible beneficiaries for super?
So for super, we have to remember that, and you're right, because super is never front of mind for people who are not near the retirement age. It's always like, oh, that's just something that comes out of my paycheck every week, and I don't even check statements. Anyway, to be a dependent for superannuation purposes, you have to, so spouses definitely fall under that dependency bracket. Also, children, and they can be adult or minor children. But then we have this interplay of strategy around where to pay that super fund if you have adult children and minor children. So if you are a beneficiary who is a minor child and or a spouse, you're going to receive that money, tax free, but there might be a different strategy we need to put in place for adult children. Anyway, there's also another class of beneficiaries, so someone who is interdependent on the deceased. And that might be like a parent who does live in your house. That would then possibly, typically be a valid nomination, but you have to be really careful.
That's quite a rare, like it does happen, but I find that there's not an awful lot of people out there who do have an interdependency relationship with someone under the specific guidelines of that. Yeah. And then the other option is, of course, to direct the money to your estate, your legal personal representative, and it be dealt with under your will.
That's right. And typically that's a strategy for, that is just a strategy people don't realize exists. They will always, if they have a nomination in the first place, it will always be to someone in their close circle. So I've seen a lot of single people, though, appoint like a niece or nephew, their favorite niece or nephew. And I'm like, that's going to be an invalid nomination. The frustrating part about putting those nominations in place without legal advice is that those super funds accept that documentation and they'll take your account. You feel like it's valid. You're like, well, my niece's name is on there for 25%, or my nephew's, my parents' names are on there. And I'm like, it's not until that documentation is being processed that the super fund actually goes deep and sees whether the person fits within that definition of a dependent for.
Because if they're not your spouse and they're not your child, the only other valid way for someone outside of that would be within that interdependency relationship. So it's not to say that your niece and nephew can't receive your super or your life insurance proceeds, but it needs to be done via your estate, via your will.
Yes, sorry, going back, you did say that earlier. So have a look at your superannuation nomination form. You'll see like beneficiary 1, 2, 3, 4, and there's always a space. It might be like a big section or a small section that says my legal personal representative / my estate. So that is another strategy that a lot of people need to use, but you need to get independent legal advice about when to use that. So that'll bring the funds into your will and then be dispersed via the terms of your will. But sometimes it's not the best thing to do. Sometimes it's a risky thing to do.
Pros and cons of everything.
Pros and cons of everything. And my job, a lot of it is to advise you about the risks of certain strategies, right? So if bringing it in the will or to your estate is going to be risky because there's a blended family situation, or there's so many different scenarios where it's a risky thing to do, that is my job, right? Well, typically people know that wills can be challenged, but that is the risk zone.
Keeping super out of the estate means that money can't be challenged, but bringing it into the estate means that it can be challenged. Then there would also be tax implications as well, differing between them. Like there is a lot to know.
There's a lot, and that's why. So we weigh it all up. We go, okay, here are all of your options. Better tax-wise to do it this way, or it's better risk-wise to not do it that way. So then you've got it all on the table and you make the decision based on a really informed discussion, robust discussion around this.
And I've noticed when reviewing options for estate planning lawyers, everyone kind of has different ways to do things potentially, but I know something that you quite often do is in relation to testamentary trust. Do you want to dive into that a little bit?
Testamentary trust can be an amazing way to leave your inheritance. What we're doing is we're creating a trust within your will that sits dormant. So a lot of people get worried, like, oh, if I do my will today and you're putting a testamentary trust in it, am I going to have to pay the fees from the day I sign it? No. It sits dormant and it's only enlivened on your death, right? In there, we create a trust that holds the inheritance that you would typically leave to your spouse and children in their personal names. We leave it in a trust. And the asset protection that a trust provides, and tax concessions that this particular trust can provide to especially minors, you won't get that if you're leaving it via just a simple will. So a lot of people know about simple wills, everything to my wife and children or husband and children, but we pay it to this entity that is this testamentary trust. And lots of people know about family trusts, trust that you put into place now while you're alive. This is only enlivened on death. So the reason there are tax concessions for minors in that trust that are not available for, say, a family trust that you put in place is because the law recognizes that unfortunately someone's had to die in order for this particular type of trust to come into play. So there are tax concessions in there that are available that are not elsewhere. And trusts can last for 80 years. So if used really well, your great-grandchildren can benefit from your hard work.
I'd actually never thought about that. That's a really good point.
Well, everyone talks about generational wealth creation. That is me going, I can give you that. Like I can give your family that. But obviously it's all about strategy. Sometimes it's really based on your personal circumstances. So, but when it's available, they're an amazing estate planning tool.
So as well as some pretty hefty tax savings potentially with testamentary trusts, what about the situation whereby, so husband and wife with children, husband passes away, wife remarries with a testamentary trust and without a testamentary trust? What might that look like?
Oh, it does get a bit complicated, but with trusts, what it comes down to is that if the assets flow into a trust, nobody owns them. It's the trust, so beneficiaries who are named under the trust deed can put their hand up and say, consider me when you distribute income or capital from this trust this financial year. But the key is getting the trustee and the appointor trustee role, really, because they're the person who makes the decision about where to distribute funds every year. So say it's the wife who survived, first 5 years, it's just been her and the kids, she's making distributions, it's nice and easy, and then she repartners. She best come back to me if I've drafted her will, because it's all about getting the control factor right. It gets a bit murky when people repartner because then the family laws kick in. Trust me, family laws, they just have a really long family courts can bust down trusts if they feel like what was within the trust should be part of relationship property. But if you've got a trust in the first place, you're ahead of the game, because had wife assumed that inheritance in her personal name, there's no question it's part of the relationship property, unless she somehow divested those assets elsewhere out of her name before she's repartnered. So it's all about, like, testamentary trusts in that nice, neat nuclear family scenario, always the go-to, but it's getting it right along the way. If and when we can bring children on to be either co-trustees or, mum bumps off and, maybe takes a bit of money, but the kids can... Well, we talk about bumping trustees off and, bringing new ones on. Well, because she exposes a risk to that inheritance if she doesn't manage those trust funds correctly. It can just get a bit murky if she's using that money to, buy a new home with this person.
The assets, the inheritance from the spouse that passed away, I guess really for the benefit of the surviving spouse and the children, not necessarily a new partner and their extended family as well, potentially. So that can be another reason to prompt people to explore whether a testamentary trust might be right for them. I know that a lot of people, so you've got 4 options. You can not have a will at all and dig your head in the sand forever. You can go and get a post office will. You can go into the public, your face. You can go to the public trustee and get a will, or you can see an estate planning lawyer. What's the problem with post office wills or public trustee wills? So they probably all have their place, maybe, but what are the issues that you see with those two in particular?
So many issues. Honestly, so many issues, because people aren't aware of the technicalities of even drafting and signing and witnessing and ensuring that the contingency plan after your first lot of gifts is dealt with. So some people will draft a will assuming these post office wills give me the heebie-jeebies. I do not think they're worth the paper that they're written on. People don't realize how technical it is. How technical the laws that surround what you own, because it's about what you own. Going back to what you own and how you own it, you're assuming that 2-page will that hopefully has been signed properly and all of that, will stand up against different scenarios. So if you've just given everything to one person and then not dealt with if that person is predeceased me or before the money's distributed, where that goes. So I've seen a lot of these DIY wills actually, either if they're not considered invalid because of some technicality, they fall into the intestacy laws anyway.
So you may as well not have had one.
Basically, and we're talking about a lot of money. Again, people don't realize how much their estate is worth. And so the investment in seeing a lawyer, like, yes, it's a couple of $1,000. Well, depends on who you go and see and what package you get. But that clears up so much mess post-death that we've seen. And when it comes to a will that doesn't stand up and therefore falls to intestacy laws, and then family members put their hand up and, say, I want this and I want that, and appoint me here and appoint me there, that can cost your estate so much more than if you had just gone and seen a lawyer to get the plan right in the first place.
Yeah. And how about, like, I've certainly heard a lot of stories in relation to public trustee wills, specifically where the public trustee is nominated as the executor. So they don't charge to actually make the will, but then they charge to be the executor. What does that look like?
Don't hold this against me. I used to work at the public trustee. I used to work for the official solicitor to the public trustee. So yeah, I did, yes. And it was my first job here, practicing here in Australia after practicing in New Zealand, because that's where I initially practiced. And I was like gobsmacked because there's not an equivalent. Well, the public trustee in New Zealand doesn't have the equivalent powers that the Queensland public trustee have. I was like gobsmacked, like, wow, this is happening. Anyway, to answer your question, yes, I think they typically say, come and do a free will. But if the public trustee is appointed as your executor, they will definitely charge fees in the administration process. So to be an executor, there's quite a bit of work to do. You're calling in assets, you're paying debts, you're paying funeral expenses, and then you've got the job of administering the estate to the right beneficiary. So it can be a big role, and the fees that they charge just astound people.
They're percentage based.
Yeah.
So if you've got an estate of, $3 million, you're probably and potentially someone may, even in their 30s, have an estate of $3 million. If they've got, $2 million of life insurance and a net worth of $1 million, that quickly adds up in terms of fees. What was I going to say? I lost my train of thought. It was something to do with
don't get your will done at the public trustee.
Well, you can. Oh, that's what I was going to say, actually. So the reason why they have fees is, well, they're not a charity. Like, they actually have to pay their staff and everything. Whereas if you nominate, typically what I see is people nominating an executor that is also a beneficiary. So, you don't mind doing all of that administration side of things as an executor, knowing that you will actually be, I wouldn't say remunerated for it, but there's a benefit to you. Whereas, the public trustee being the executor, they're not getting anything out of it necessarily. So that's why they charge, right?
Yeah. No, keep it within your circle. Like, keep it, that's a big part of the discussion too, is who is the right person that can fulfill this role. It's a really important role, and you can have backups, so we make these documents really robust so that they last through different life events as much as we can. But it's never a set and forget type of document. It's something you have to kind of keep working on as you progress through life.
We need to wrap up a couple of minutes early today, but if anyone has any questions about estate planning, you can reach out to Lana directly or send them into the platform Finito. We can always get Lana back on, but I hope that gives everyone a little bit of a kick to take your head out of the sand, because we know about 50% of people at least that responded to my poll this morning don't actually have a will, to prioritize that part of your life admin and get that weight off your shoulders. Thank you for joining me today, Lana, and I will see everyone next week. We've got another special guest next week, an accountant next time. So I will see you then.
Thank you. Thanks for having me. Bye.